All right, now I'm not muted. All right, we're back. I switched out my headphones, so maybe this microphone is better. If you weren't here for this morning stream, I am traveling, and so I'm in a different location without my ginormous microphone. But hopefully you can hear me okay and see me okay, and hopefully there won't be too many complaints this afternoon. We are coming back for the charging conference on the Karen Read trial. The case is over. The defense has rested. Now we're going to talk about jury instructions, and tomorrow morning, first thing, we're going to see closing arguments. My prediction is that the jury will get the case before lunch. They will go to lunch, and my prediction is there will be a verdict tomorrow afternoon at some point. Shiraz sees sunlight. I put a poll in the chat, so I'm interested to see where that poll is now. Is it still in there? Doesn't come up on my TV. I don't know. I mean, on my phone. I don't know why. Did it end when I went live? I don't know. YouTube is not really, is really wonky today. Is anybody else having trouble with YouTube today? Or is it just me? It's probably just me. Very possible. It is quite very possible. Thank you, Saniel, for becoming a new member. Welcome, welcome, welcome. Welcome. Mindy says she thinks the verdict will come quick as well. Will it be that fast with all the evidence? Well, you know, I mean, what if they go in and they take a vote, which is sometimes what they do, and they say, everybody's saying guilty, not guilty, and they all raise their hand. And they say not guilty. They could eat lunch and come back. I don't know. There could be a holdout. You never know. 98% not guilty. Why is it not showing up on my own damn phone? Because, you know, somebody wrote YouTube sucks. Oh, the other problem is, look, I think Law and Crime is the only one that's going to broadcast this charging conference. I did not see it up on Court TV, so I don't think they're going to cover it. Although I was getting ready and doing some things and trying to grab some lunch, and I heard some volume, and I came on and they were showing a different conference. I think it was on the Walsh trial. Did you guys see that? They started showing the Walsh conference, Brian Walsh, which is in front of Judge Beverly Cannoni as well, I think, right? Was it the Walsh conference? Adam Drives Helen says, over under set at 2.5 hours. What do we got? I don't know. I feel like it's going to have me for lunch. They like to get their free lunch. And also, it's really hard to deliberate when you're hungry. I mean, you should never grocery shop when you're hungry, right? So can you imagine deliberating on a murder case when you're hungry? I'm gonna go under. I'm gonna take the under on that, Adam. Are you the bookie for us? Are you the bookie? Yes, it was the Walsh case. Okay. So that's in front of Judge Cannoni as well. The Walsh case, that's interesting because I thought she wasn't going to be a criminal judge anymore. I thought she's a civil judge now. So why was she hearing that case? If anybody who is local knows why, please let me know. A lot of people have the under. Hello, Ann Bozzarelli. A lot of people taking the under at 2.5 hours for the jury deliberations. It is done for today, except they are going to broadcast the charging conference, which has to do with the jury instructions. And the jury instructions are really important here because the defense wants to include all kinds of what they call LIOs, or lesser included offenses. So they don't just want the jury to be able to deliberate on the second degree M charges. YouTube doesn't like that word, but they want them to be able to deliberate on some lesser included, which, you know, like, look, why did you charge her with second degree if you think it's not? I don't know. I just don't like that. So perhaps the defense is going to argue against it and say, look, either you prove the M charge or you don't. That's it. We'll see. Oh. Well, that would help if I push play on the Law and Crime stream. All right. They still didn't start yet. Ooh, whatever you do, do not look at that chat. You do not want to see that chat. It's not friendly there, but you know that. If you know, you know. And I know you guys know. So there's that. So under. Karen Peck, after watching what happened in Canton last night, how can Karen live in that area again? Well, she never did live in Canton. She lived in Mansfield, right? So I don't think that she ever lived there, and I don't know that she will, and I don't really know what happened because I still didn't have a chance to catch up on it, but you guys are telling me there was some shenanigans with some of the players in this case. Melrose says they will want time to decompress and finally talk to each other. Yeah, they haven't been talking to each other. They're not supposed to talk to each other this whole entire time while the case was going on. So it may take some time to talk to each other. You are correct about that. Sherry Wilson, who's the female they just announced something about? That is Sandra Birchmore. They just announced that they are now calling it a homicide. Sandra Birchmore was a young girl. I don't know enough about the case to really talk about it. But she was allegedly groomed by some police officers, some of whom I think may be involved in the Karen Read case from the time she was a young girl, teenager. And allegedly, they said she took her own life. I don't even know the date or anything about it, but she was pregnant. And many people have been screaming for a long time that she did not take her own life, that this happened to be someone else taking her life. And they have just decided to treat it as a homicide. Somebody sent me something about it. I haven't even had a chance to look at it yet, but that was announced while we were on our morning stream. So that's interesting. I don't know if the federal investigation had anything to do with them changing the determination that it should now be considered a homicide, but that is good news for justice for Sandra Birchmore. The poll scares you. I don't know what the poll says because I can't see it. I can't see it because I don't know. It disappeared. Give me 2 seconds. I'll be right back. I'm back. I mean, Law and Crime says they're coming back at 2:30, but it's 2:32, and the judge might have had to go back and had to have a coffee or something. So, I don't know if I can pull the poll up on my laptop. Somebody tell me what the poll says. I think YouTube is breaking today. It's broken because of this trial. And now that we probably think we may have a verdict tomorrow, that'll be good stuff. Thank you. Canton Expat says her case is in Stoughton, which is the next town over from Canton. That's Sandra Birchmore. I think we're going to have to do a deep dive after that. Some people voted guilty on the poll by mistake, so maybe that's going to skew the results. Somebody says the cops took her out. Bayou Babe definitely needs to know more about that. And so sad. Tanya says, hey, Robbie, definitely worth researching, says Robbie. Oh, and Stephanie says it was Canton PD who did that investigation. Go figure. Go figure, Sandra Birchmore. Shock and horror. Shock and horror, my friends. Marvin says the FBI already know the verdict. After this trial, there will be another. Awesome. Thanks, Amy. Thanks, Amy. Amy's so show. Thanks for telling me the poll results because I can't right now. Hold on a second. Can't see it. YouTube's broken. Lank was involved in that one too, Ken? Same phone guy, Guarino, right? Guarino was involved in that too, right? Yes, thank you, Sparkly Rabbit. It says, I believe Sandra Birchmore was underage and also groomed by a police officer, right? And there's some speculation that she was pregnant with perhaps a married police officer's baby, right? And will Mark be joining me for the verdict? I have not spoken to Mark at all, so I do not know. Exil said, I bet Proctor's doing the investigation on Sandra. I think you mean Sandra, not Thara. As Dark Communication says, for the large number of Massachusetts public officials going to trial, you'll be back soon. I'll be back. I'll be back on the airwaves for the local Canton stories. I have a feeling this is not going to be over with this verdict. I have a feeling. Thanks, Stephanie. She says, this is Sandra Birchmore. The state did not change cause of death. It was an expert who was hired by the parents to perform another autopsy based on my understanding of what I read. Somebody sent me the article, but haven't you had a chance to look at it? Coffee Cafe says the cops groomed her for years, and Twitter is going crazy right now, says Kelly Grubin, with regard to Sandra Birchmore or with regard to what we saw this morning, the defense experts who all say Officer John O'Keefe was not hit by a car and a car did not hit Officer John O'Keefe. Hello, Sharing. Sharon is the president, the head of the Rage Crochet Club, and she says, will we ever find out the truth of what happened to Officer John O'Keefe? I don't know. I should do a poll on that because I don't know. I genuinely don't know. I wish for his family and friends that there could be some sort of finality, some answers, but that is it's crazy. Makes me wonder. So maybe when Proctor's charged, he can get AJ for his lawyer. Wouldn't that be a hoot? I don't think AJ in a million years would take any amount of money to defend that guy. And I also, could be considered a conflict, but that would be must-see TV. Oh, thanks, little cupcake. 1,500 votes, 97% not guilty. All right, so there's about 1,600 people who are here right now that did not vote. So if you guys want to vote, it's still up. Albert and Lank, Guarino and Fanning, Catherine says, were all involved in Sandra Birchmore. You mean Kevin Albert? Oh, so Kevin Albert is involved in the Sandra Birchmore investigation? Oh, that's interesting. Huh. All right. Court's back. I mean, according to the audio.
Preceding court is in session.
So before we start, there's something I do want to talk to counsel about at sidebar.
Cool. Sidebar. We're ready with the sidebars. All right, let me go. So we're going to talk about jury instructions, I think. Maybe about some things like the late discovery that was exchanged on Friday, which didn't even come into the trial anyway, so no big whoop, didn't really matter. No big whoop. Canton expat says the Birchmore died in Canton but was from Stoughton, where it's alleged she was groomed to be some officer's side piece, died while pregnant. And wasn't she in some sort of young, middle school sort of explorers club that was run by some police officers, right? So they knew her since she was younger, like 13, 14, 15. That's so frightening. So frightening. And Lucky We Trust says, pretty sure Lank wasn't on duty, but still showed up again. Lank likes to insert himself into things, right? Things involving the Alberts. Is that why? Because Kevin Albert was involved in that somehow? Tell me how Kevin Albert is involved in the Birchmore case as an investigator or as a person who hung out with Sandra Birchmore. Rich MacArthur, some of the same dirty troopers are involved with the Birchmore case. The cop that allegedly took her life deleted his calls and texts too. Oh, shocking. And then what? Let me guess. Trooper Guarino did the cell phone forensics on that, right? For Sandra Birchmore? Interesting. That's interesting. Child of God says, I don't think we'll ever know the truth of really what happened that night. I think you're probably right. Noni's Treasure House, thanks for the 5. How can they charge her with lesser charges if they didn't prove she hit him? If not guilty, someone is. Have to find out who, right? It doesn't seem that logic really happens in Norfolk County system. It doesn't seem that way, but yeah. Maybe they're going to try and show some lesser includeds that don't involve intent, accidental, vehicular manslaughter, just a DUI, perhaps. On civil, I always assume there's a 5% base chance of conviction just based on the fact that there's a defendant sitting at the defense table. It's happened before, yeah. And people might say, well, she didn't testify in her own defense, therefore she must be guilty. They're not supposed to think that, but some people do. Brass, thanks for the 5. Yes, Kevin Albert was the detective from Canton PD sent to investigate. Guarino claimed that there were no messages between the 3 Stoughton cops, couldn't find them. Oh. I mean, can Guarino find anything that's right in front of his face? We started calling him Trooperino during this trial. Trooperino. Jillian says, this has consumed my life for the past year. Ireland supports Karen. Hello, Ireland. Slancha, my Irish friends. It's consumed a lot of people's lives who don't even know Karen or have any relationship to her whatsoever or any of the players in this case. But a lot of people are trying to stand up for justice. Couldn't believe what was going on here.
Unmuted.
Thanks, Jillian.
All right, so the charge conference, the first question I have is regarding I'll go through them in the order that I have them in my very rough draft, but there is no request of the lesser included offense of voluntary manslaughter to the 2nd degree murder charge. Is that what the Commonwealth's intention is, not to request an instruction on voluntary manslaughter
Voluntary.
as a lesser included of the 2nd degree murder?
I'm sorry.
I think Mark's on trial for the next 3 days. I think he did say that, Ashley. I think you're right.
That's correct, John.
Okay. And neither side has requested an instruction of a lesser included of OUI?
Operating
That's correct
under
as well.
influence.
And the defense is not requesting that?
That's correct, Ron.
Okay.
That's operating under the influence.
All right.
Called GWI.
So. All right. So the first instruction, the request from the defense is that I split the charge, and it's written that way. I'm not going to split the charge. So the way it'll be is the defense will argue first, then the Commonwealth, and then I just go through all the instructions. So aside from that, the first instruction is presumption of innocence. I have one that I typically give, but I will give the one that's requested by the defense. Next instruction is our reasonable doubt instruction. Then function of the jury, the arguments of the lawyers and the judge's comments, function of the judge, functions of the lawyers. Verdict must be based on the evidence. I've incorporated some of what you've both included into that. I have language here that similarly, as you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try and guess what may have been removed or why. I think that came from the defendant's request. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any comments I made, the lawyer's opening and closing statements, and any comments they may have made are not evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witnesses, that is, their answers to the questions and exhibits, are evidence, with a more robust instruction, but that's what I've added. And I do have a line about sympathy. Then I do the view. I should say right off the bat, I am not going to give a Bowden instruction. You can argue it. You've been able to put in a tremendous amount of evidence. I've given you a lot of leeway with that. But there is something in this case that and I'm fully within the law to do that. So,
okay, she doth protest too much. So the Bowden defense is the defense that you couldn't possibly find my client guilty because of the shoddy investigation that was done. I don't know what the pattern jury instructions from Massachusetts say with regard to a Bowden defense, but anytime this judge says, and I'm well within my rights to do that, it makes me think that maybe it's not.
I have here some language that I think is appropriate based on issues that were raised about the credibility of witnesses. Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the evidence presented. So I cover the bias part of that. And we'll go through and you can tell me who's going to argue this for the defense. Okay, so we'll go through and we'll do each one. The limiting instruction.
All right, so that indicates to me that Alan Jackson is doing the closing if he's doing the arguing.
I give the defendant's bad acts instruction. I'll give a similar instruction on the digital evidence that I did during the trial, photographs and testimony with an emotional impact, humane practice, and as of today, hypothetical. I had hoped that both of you could suggest something. I said that this morning. Do either side have anything for me on hypotheticals?
Because they've had so much time to prepare, Your Honor.
Sorry, I don't, Your Honor. We're going to be getting back at a fairly early hour. I'm happy to work on it.
That's fine. I mean, I can do it, but I wanted to
Wait.
give you both the opportunity.
Wait, that sounds like Mr. Yannetti. Does that mean that he's doing the closing? I thought that I heard Alan Jackson's voice before, so I don't know.
Yeah, go ahead and do one and send it to me.
I'm happy to do that.
I'll have one to you by the end of the day.
Okay, thank you. All right. Opinion testimony, evaluation of exhibits, direct and indirect, and circumstantial evidence. So I received today defendant's request, a late request for the law allows both direct and indirect evidence, and there is no distinction to be given. A conviction, however, may not be based upon the piling of inference upon inference or on conjecture and speculation. I don't think that's exactly the language from the case law here that you've cited. There,
I actually quoted it, Your Honor.
so from which one? From Haunch or?
French quotes McCormick, and McCormick takes the law from Dustin. There are
Yeah, so
multiple cases that
right, and the language that is typically given on this piling that I haven't really seen in years is you should not pile inference upon inference until the pile gets so high that it tips over logically or the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure they're still reasonable. I mean, I could give that old language. All right. That's,
we prefer that.
I haven't given that in years, but I'll give that part of it.
Just because you haven't given it in years doesn't mean it shouldn't be given in this case, Your Honor. And yeah, Kenny says that the voting defense is at the judge's discretion. That is correct. And we did all the pretrial motions on that. But I don't know what the actual jury instruction says. She's not going to give the jury instruction. So yeah, I agree. I'd like to know what that jury instruction says. Maybe I'll look it up later in my free time.
And just to finish off
No
that
juries, no.
paragraph, when the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all the evidence and reasonable inferences that you have drawn taken together prove that she is guilty beyond a reasonable doubt. Okay, so that rounds off that. All right. All right, so now we'll talk about the indictments and the lesser included. So the second degree murder instruction that was provided by the Commonwealth and the one provided by the defense are just a little bit different. So if you take what was provided, there's one section that the defense incorporates that I think is missing from the instruction, and I'm going by the SJC instructions. So when you get to the second element of second degree murder, the defendant intended to kill John O'Keefe. The second element first prong. So the second element is that the defendant intended to kill John O'Keefe. As you can see, the second element has 3 sub-elements. I'm reading from the Commonwealth's proposed instructions, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the 3 prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill. Now here, I am going to insert, because if you go back to the SJC instructions, I think it is appropriate to go back to the instruction on deliberate premeditation, which is the second element of that, is the language that is offered here by the defendant, that the defendant consciously and purposefully intended to cause the death of John O'Keefe. So who's arguing this for the Commonwealth? So Ms. McLaughlin, does that make sense there?
Yes, ma'am.
Okay, so I am going to put that in there. All right. And the defense has the language of accident there, but Mr. Yannetti, that really goes at the end. That goes, as you'll see if you look at the instruction on extreme atrocity or cruelty, where you have to go. So that'll go at the end. That will go after the third prong definition. Then I will include the language that I think the Commonwealth put in its request. It goes there. If you have a reasonable doubt as to whether the victim's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have created a plain and strong likelihood. Then you have in deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. You may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of alcohol or drugs. That goes there.
That's fine, Your Honor, with us.
Okay, does that make sense to you too, Ms. McLaughlin? Okay. All right,
It's not you. It's really hard to follow this when you're not looking at a copy of it because they're kind of skipping all over. So it's not you, it's them.
want
And
both amendments?
This has not really been, it's not public. I mean, part of it is, I think only the Commonwealth's suggested jury instructions have been out there. So I haven't seen both sides of it. So it's hard to follow and comment on, quite frankly.
Mental impairment or consumption of alcohol and drugs? Oh, do you want to just leave the whole generic sentence?
I think we can, yes.
Is there any objection from the Commonwealth on that?
I don't believe there's any evidence of mental impairment, but the Commonwealth has no strong objection.
All right, but
Where's
there's
this come from?
there's
I think
no
just say the whole
evidence of
trial.
drugs either. So do you want it to just be alcohol?
Right.
Just that would be most in line with the evidence, just to have intoxication under alcohol.
All right, it makes sense to me, Ms. Giannetti, if we focus just on the alcohol, but if you wanted the mental impairment, I'd include all, but
I would prefer just to keep it in and just jump as
all right, so I will think about this one tonight, okay? Okay, then manslaughter while operating a motor vehicle under the influence of liquor. So, Mr. Yannetti, you have included in the language, what does it mean to be under the influence of alcohol? That paragraph that starts after the third element? Yeah.
I'm sorry, Your Honor, is there a page number on through my?
9.
9.
I agree, John Monaco. I don't think they proved that John was hit by a car either, but that's going to be a question of fact for the jury to decide.
I have it, yes,
All
sorry.
right, so you have included, it means that a person has consumed enough alcohol to reduce their mental clarity, self-control, and reflexes, and thereby left them with a reduced ability to drive safely. Where is that language from?
Where's the real evidence that she had 9 drinks? There's been no receipt produced that said that she had 9 drinks. There's been no video of her drinking 9 drinks. There's been maybe 9 things of clear liquid. Nobody's ever really proved what was in the glass. Did I miss that portion of this trial? Because last time I checked, I was here with you every single day except for the day that I actually went to the trial. So I haven't seen it.
Particular portion of it, I thought was from the model instructions. If I'm wrong, then we're fine with model instructions on this issue.
All right, what does the Commonwealth say?
The Commonwealth
He's garbled. He's got no microphone, Mr. Yannetti or Misty and Eddie. So it's not you, it's them.
language comes from the model and jury instructions, I believe from the most recent 2024 instruction on intoxication.
And that's not in the Commonwealth's request, correct? That sentence I just read?
On page 5, third paragraph, it's either a similar sentence or a
Yeah, it's a similar sentence, and I was just having both. It was, a person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected or emergencies. So we don't need both, Misty and Eddie.
No, because you said
So you had
It was
both, so
intentional.
I'm just not going to do that.
We're perfectly fine with that.
Okay?
Kim, don't believe everything you hear. She never admitted to having 8 drinks. She admitted actually on Nightline to having 4. I'm also kind of interested as to why they never showed that Nightline interview during the trial, and also why they never called Gretchen Voss as a witness from the Boston Magazine interview that she did with Karen Reed. Because remember, there was a lot of pretrial motions about whether or not the Gretchen Voss had to turn over her notes and the outtakes from Nightline and all that stuff, and they never called her. They never played the Nightline interview for the jury, so I don't know. Did we miss something? They can't. They didn't.
So under the second theory, so the Commonwealth is proposing the theory of the 0.08 or greater. The evidence supports that. I'm going to do that. So in the language from the Commonwealth, the fourth element, now then we talk about wanton and reckless. So for the fourth element, Ms. Giannetti, this is where your language.
A lot of comments in the chat about, what about everybody else? Everybody else was drinking and driving too. All the cops were drinking and driving. Everybody was drunk. Why aren't they? It's none of that matter. I hate to break it to you, but none of that stuff matters. Doesn't matter. Doesn't matter what all those other people were doing. Doesn't matter. This case is about Karen Reed and Karen Reed only. So none of that stuff is factored in here. And I don't think they showed that she had 9 drinks. I don't think any of that extrapolation evidence was valid. I don't think the testing was valid. We don't know if she went home and drank a half a bottle of vodka. We don't know anything. We don't even know what was in her drinks. And the jury has to consider all of that stuff, but they're not going to consider anything with regard to anybody else who was drinking that night and driving. So it's not a factor, unfortunately. I think Lally's doing origami right now. The bartender.
You have language for 5 that actually belongs in 4, I think. I'm just going to find it.
The bartender from the Waterfall testified, but not the bartender from McCarthy's, right? And what did she even say?
On the foreseeability,
Very early.
I think that belongs under 4. And that's where I'll have it. Okay? Belongs at 4 instead of 5. Do you agree with that, Ms.
No, yes, that's fine.
Okay, do you agree with that, Ms. McLaughlin? It belongs under 5?
yes.
Okay. All right. So I'll keep it. I mean, it belongs under 4. I'll keep it at 4 and not have it at 5 where you put it, Ms. Giannetti. Okay? All right.
Please refrain from breaking news in the chat.
I am going to give the lesser included offense of involuntary manslaughter.
The receipt from the waterfall said 2 Tito's and a Bud Light, right?
So there's additional language that I have found helpful in other cases. When I discuss the language and the cause of death, remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. And then the next sentence is a defendant's act is the cause of death where in a natural and continuous sequence results in death and without which death would not have occurred. Okay, so those two sentences I find go better together, Ms. Gianetti. Is there any objection to that?
No, I understand.
Okay, any objection from the Commonwealth?
Zero. Ann says, what are the
so
chances
Misty-
of Bev overturning the jury verdict to guilt if they come back not guilty? No, that could never happen. It can't happen that way. It can happen the other way. If they come back guilty, the judge can overturn the verdict and say it's based upon the weight of the evidence. They couldn't have ever have decided that, but it can't go the other way around.
Gianetti, you have in here a police officer's opinion about a driver's sobriety, like that testified to in this case. A police officer didn't testify as to the defendant's sobriety. So,
I think you're right.
so okay, so that paragraph that begins with that, we'll just cross that out.
I think that's fine.
Okay.
Jennifer, they have to put her behind the wheel of the car, and I don't even know if they've done that, except some witnesses said she was behind the wheel of the car, so.
In this same instruction, I have included in the paragraph, in deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another. Some portion of the sentence that I'm going to think about tonight, I have, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of alcohol. Okay. Any objection from the Commonwealth on that?
No, Your Honor, that was requested by the Commonwealth, if you could consider it, please.
Yep, so that will be in that last paragraph of that offense, Mr. Linetti. Okay, then the lesser included offense, motor vehicle homicide, felony, OUI, liquor, and negligence. I'm going to give that. So I don't have anything because you didn't, the defense didn't propose any lesser included. So I didn't see anything that was inappropriate about the Commonwealth's instruction, Ms. Gianetti. I've added, I think, one line that a person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by failing to do something that a reasonable person would do. It's obviously the law, right?
Right, that's the law of negligence, and I do understand the law of lesser included, and, you know,
Okay.
right, I think that.
All right. Thank you. So leaving the scene of an accident resulting in death. So what the Commonwealth has provided is basically just the six elements with nothing further. They're pretty much 1 and 2 have already been defined for the jury many times at this point. 3, the defendant knowingly collided with John O'Keefe. I think that's self-evident. So, Ms. McLaughlin, why don't we start from here? Why did you just give me the 6 elements?
Your Honor, as you suggested, the first 2 have been defined extensively for the jury, and I believe the other 4 prongs are self-evident, so they don't need further instruction.
Yeah.
I think it would
Not ready
be
to argue them, apparently.
sort of redundant or
Apparently.
unnecessary to explain to a juror what failure to provide documentation of registration and things like that does not warrant additional instruction.
It
Do you
sounds
think
like
they
Kurt,
need to listen to me any longer than necessary, Ms. Gianetti?
We're in complete.
Kurt says, wait, I'm confused. I thought the parties didn't ask for lesser included. Is she giving lesser included anyway? It sounds like she was charged with both. So I don't think they're adding any lesser included, but without looking at a copy of exactly what they're looking at, it's hard to comment on this. I'm going to have to look at it more closely, but they charged her, I think, with both, with second degree murder and then also with vehicular homicide, felony homicide under the influence. I think there were two charges, not necessarily, one was not necessarily a lesser included of the other.
Agreement. Maybe for the first time in this.
All right, so we'll just leave it. You've offered 2 pages or 3 pages of definitions, so we won't do that.
It's fine.
Okay. All right. Ms. McLaughlin, the use of a dangerous weapon, a motor vehicle, I agree that's an appropriate statement of the law. Tell me about your request to have that.
Your Honor, the request goes to the defendant's state of mind. Also, it would go to any intent or any understanding of the jury of what would be reckless conduct or negligent conduct or intentional conduct. If
It's
they
actually murder.
understand that the use of a motor vehicle to commit a crime could be a per se dangerous weapon, and in using that to strike an individual, that could be used in their deliberations, assessing the defendant's intent or state of mind at the time of the collision.
It seems to make sense, Ms. Tianetti.
My position is it's unnecessary, but I'm going to waive argument beyond that.
Okay. All right. I think it makes sense, and I'll just leave it sort of as a catch-all at the end where it appears on the Commonwealth's request. All right. So that's basically it. The longest part maybe is the general instructions in the beginning. Anything specific from the Commonwealth that I did not include?
Do you intend to give a consciousness of guilt instruction?
Oh, I'll hear you on that. I don't, but you can try and convince me if you want.
Your Honor, the Commonwealth would put forth that there's been sufficient evidence that the defendant has engaged in actions that go to a consciousness of guilt. There's an inference that the defendant deleted portions of the Ring video, a narrow area of Ring
Inference is
video,
not-
of Ring videos that are missing.
No.
They begin with Mike
No.
Camerano picking up his daughter at 11
No.
a.m. They resume at 5:07 when the defendant backs her vehicle into John O'Keefe's. Then there's a period missing where the defendant shows the broken taillight to Jennifer McCabe and Kerry Roberts, and then the video resumes again when the victim's niece gets picked up. But not only the
That's right.
missing Ring videos, but also the defendant's behavior. What began as testified to from the Dighton police officer, the defendant's father called the Dighton Police Department and requested a ride to the Good Samaritan Hospital
Okay.
due to the weather conditions. He then drove himself to Brockton to pick up the defendant and perhaps bring her home. What they do in the middle of a blizzard is now Dighton to Brockton
They?
is half a distance. Then they travel further all the way back to Canton.
Wait, I'm sorry. So now are her parents involved in this murder too, Ms. McLaughlin? What? Yeah, their own witness said that she did not have access to it, that it wasn't on the computer, it was only on his phone, that she didn't have access to it. So where have you been, Ms. McLaughlin, and why are you even speaking right now?
And to retrieve the murder weapon, along with the defendant's brother.
Retrieve
They
the
all
murder
meet
weapon.
at the victim's residence to
Oh,
remove
girl.
the murder vehicle and bring it all the way down to Dighton, Massachusetts. That would go to concealing evidence and intentional. There's also evidence of the defendant's statements going to her consciousness of guilt.
Concealing evidence? Wait, are you charging the parents and the brother now too? What are we talking about here? Wow, just when you think this couldn't get interesting.
Within hours after John's death, the victim's sister-in-law calls the defendant, reaches out, wants to make sure she's okay.
Yeah.
The defendant says to her, I only have to remember the bad times. You'll likely never hear from me again. Erin O'Keefe testified that she tells the defendant, of course we are, we're friends. She's never heard from the defendant since. So I think that goes to the defendant's state of mind and the hours.
She's never heard from the defendant since because as part of her bail conditions, she was not allowed to contact the family. Ms. McLaughlin, have you been listening? Do you know anything about what's going on in this case? What? Consciousness of guilt because Karen never reached out to Erin O'Keefe again? Wow.
Hours after the death, But in addition to the ring video, I think there's strong evidence of consciousness of guilt to move the murder vehicle within hours of John's death.
Oh my God, this is so desperate, very ugly desperation. Is she doing the
Ms.
closing?
Giannetti?
She said
Well,
nothing.
first of all, with regard to the ring video, Trooper Guarino, who was certainly no friend of the defense in this case, testified that there was zero evidence that Karen Reed had access or had access anything on that computer, and the Commonwealth utterly failed to prove that she had any access to delete anything. So I would say that that is a red herring. This is the one case, I think, a very rare case where there's much more consciousness of guilt evidence with regard to the Commonwealth's own witnesses than there is with regard to the defendant in the criminal case. With regard to the other arguments, I'm having trouble following.
So the moving the car extra distance during a blizzard, that part of the argument that the Commonwealth made.
Wow.
Right. I mean, the evidence was that my client maintained a residence in Mansfield. She didn't live at One Meadow. She spent time there. To say that moving her car to her own home,
Right.
where the police later found it because she was there and picked up the phone and said that the police were coming and she stayed there and they were able to seize the car, that does not rise to the level of consciousness of guilt.
Okay.
Kind of the defendant actually moved her vehicle to her parents' residence, so that indictment, not her residence in Mansfield, which would further support an inference that she was concealing evidence.
Concealing evidence by she didn't even drive her car back to her parents' house. Someone else did. So what are you talking about? Concealing evidence. Oh, good one.
Well, even if it's her parents' house, Your Honor, again, if she's no longer dating John O'Keefe because he's passed away, then, it makes sense for her to have her vehicle at her parents' house or her own house. Again, it does not rise to the level of consciousness.
Nor does she stay at the home of her boyfriend to grieve with the family who just lost John. She quickly comes back to the house, brings her family members, goes upstairs for about 20 minutes by herself with her father, and quickly leaves the residence.
To get her stuff? Because they've already testified, your own people have testified that the Ring doorbell footage was not accessible from the computer in the computer room. So what are you talking about, girl?
There's no evidence that she did anything upstairs or that she had access or the ability to change anything.
To get her
Okay.
stuff.
It's a little bit more robust argument than I expected from the Commonwealth. So I'm going to think about this. I'll let you know before closing argument tomorrow.
That's
And if
crap.
I don't instruct on it,
That's crap.
Commonwealth's still able to.
No, see, here's what happens, Judge. They need to go home and prepare their closing arguments, okay? So you can't decide right before they're about to give their closing arguments because either they're going to have to argue it or not. And since you only gave them each 1 hour for their closing argument, they need to decide whether they need to save some time to argue that ridiculousness instead of all the stuff that actually matters in this case, okay? That's ridiculous.
Testify to it. Witness pretrial preparation, that came out on both sides. I'm going to give the second alternative. Okay, Ms. Giannetti, I'll hear you on your instructions.
Misty and Eddie, there it is.
So I believe that we covered the vast majority of it. Your Honor.
I'll give you the opportunity to argue the Bowden one, just so you can make a record.
Sure. All right, let me just pull
Please, David Yannetti, find a mic, please.
up.
Can't hear you. It's all garbled.
I'll find your page.
Okay, so, yeah, with regard to the Bowden evidence for instruction, Your Honor, having done this for as long as I have, it's requested a lot and not given, a large percentage of the time. And I do recognize that the court has discretion to give it or not give it, and that we also can argue this is Bowden argument.
Right.
But, I think that if there's any case where a Bowden instruction should be given, it's this one. We start with the conflict of interest that existed at the start of this case, and the fact that Michael Clarkman was allowed to not only continue with the case, but to be the lead investigator or police officer during the whole pendency of the case, despite his obvious conflict of interest with the Albert family. We then moved to the fact that, we never, as a lead investigator, went into the house at 34 Fairview. We never looked around. We never checked for any signs of struggle. We never checked out the basement. We never looked for a weapon that could have been used to do the damage that was done to the back of John O'Keefe's head. We never once asked about Chloe, the German Shepherd, despite the obvious injuries to John O'Keefe's arm. With regard to the witnesses, Your Honor, witnesses were interviewed in a very relaxed manner at their own homes. There was testimony that they were interviewed together, that they were not separated out on numerous occasions. Brian Albert, Paul Albert, Jen McCabe, Matt McCabe, all interviewed en masse. Later, everybody in that group, except for Nicole Albert, was also interviewed at the same time. Chris and Julie Albert were interviewed together. And then we have all this, evidence, the way it was handled, or I should say mishandled. Starting with the leaf blowers and the solo cups and things being pictured on the floor of garages, but not being properly handled, and the fact that there are no chain of custody laws for the evidence before March of 2022. So I just highlight those, Your Honor, as examples. I believe there's more, but that's the record that I would make.
Okay, so you satisfied you've made a complete record on this?
I mean, so.
All right, but I did include some specific bias language that I read to you early on that sort of ties into this. Okay, so nothing else?
So I have one question. The defendant requested a missing witness instruction.
Yeah, you're not.
I've withdrawn that. That was crafted as the trial was ongoing. I didn't know if we were going to have that or
Yeah.
not.
Thank you for bringing that up, Ms. McLaughlin.
That was probably for Proctor. They wanted a missing witness charge, which they would be entitled to, in my opinion.
It's not appropriate.
Okay. All right, so I will see you tomorrow morning.
Question, Your Honor, is, and I haven't tried with this book before, I don't think. Do you typically send a copy of your instructions to counsel prior to?
If I have it finished, I expect I'll be up late tonight and won't have it finished in time for you tomorrow. I do give 2, maybe 3 copies to the
Nobody gets
jury
anything.
afterwards.
Nobody gets anything. Oh my goodness.
There was some question as to the use of chalks for closing argument.
Exhibits.
Permit the use of chalks for closing argument.
So can we focus on this? So does the defense intend to use chalks?
I'm going to defer myself also on that.
2,
What do you intend to use?
photographs of the vehicle and photographs of the taillight. So 2 side-by-side photographs of the taillight that are in evidence, and photographs of the vehicle, still shots of the vehicle that are in evidence.
Okay. Okay.
And that's the extent of it. for me.
Chalks are like exhibits. Big
Commonwealth have any objection?
posters.
No, but the Commonwealth also intends to use chalks.
What do you intend to use?
Also side-by-side photographs and video, but also a timeline that summarizes text messages and voicemails and significant events from January 28th through January 29th.
Okay. Any,
The request is I'd like to see that. in a-
sure, you should both exchange them, okay?
Judge, my other question is that at one point during the trial, there was a changing of 2 jurors, their seats, just for purposes of their own comfort. The way I pick alternates is by seat number.
So I'm going to ask you not to pick them by seat number, Jim, by juror number, juror card number.
Oh, okay. Well, that makes
They
sense.
may not remember what that is.
No, I have
No,
absolutely.
they may not.
Okay. They may not know their old juror number?
Their actual 3-digit number.
Right. They may not know that. Do you want me to use it?
No, if
Are you
they know it,
incredulous,
we'll use it. We'll
Jim?
talk about this.
Okay.
Are
All
you
right.
incredulous?
Why did you want to move them into, we'll talk about this.
Okay.
All right.
When is that done?
At the,
At what point?
at the end of the instruction, before I give the instruction on Be Fair, the SJC instruction on Be Fair.
Can I ask a question?
Yes,
You pick a full person?
yes. Yeah,
So sometimes it's done by lottery. I just wanted to.
no, so, right. In Massachusetts, it's supposed to be chosen by the judge.
I've seen it
So,
both ways. Thank
I know. All right. Anything else?
I need to learn more about Massachusetts law.
Yeah. All right. Thank you.
Yeah.
We'll see you tomorrow.
Board, all rise.
Well, that was a whole bunch of gobbledygook for those of us who are trying to watch a chat and listen at the same time. I'd like to see a copy of the verdict sheet is what I would like to see. Because the first question should be, was John O'Keefe involved in a motor vehicle accident? And if that comes back as no, then I would say stop, don't go any further. But that's just me, and it's hard without seeing what they're talking about to understand what they're talking about. Paul has a very stern, angry face, a sage. Thanks, Jen Shaw, hater for being a member for 2 months. So if Karen Reed never existed, the cops wouldn't have killed him. Ah, ha, ha, ha. Thanks. Lori says, am I in the Twilight Zone? This isn't in evidence. Addie became a new member. Welcome, Addie. I don't know. I think we're all in the Twilight Zone. I think we've been in the Twilight Zone all together now for a very, very long time, at least 30 days of trial. And regarding Bowdoin defense, Celery says, decided within 16 hours that Karen Reed did it. Never even searched the home where John O'Keefe was found. Right. Bowdoin defense, as you recall, has to do with the shoddy investigation, that the investigation was so terrible. There's no way the defendant could be found guilty. The judge said they could argue it in their closing, but she's not going to give the actual jury instruction. Yes, Ryan, hands down, this is the craziest trial I have ever seen. Mesa Bella says they can't believe they charged Karen at all. Nina says, I never saw a tear from Karen. The only thing that would bother me as a juror, she's innocent. A lot of people might feel that way. A lot of people might understand that she's like angry. She's angry. Maybe she should have shed a tear. That's going to be a question for only the jurors can decide that. Haas, did she ever get a trial? Says Michael. YouTube has decided they did not like the autopsy photos from this morning, so they're not. We've been stricken. We've already been stricken, my friends. But let's go back to that poll. We're going to end the poll. If you have not voted on the poll, vote on the poll now. Verdict should be guilty of murder in the second degree, not guilty, or guilty of lesser charges. 97% came back with not guilty. 1% guilty of lesser charges, and 1% guilty of murder in the second degree with 3,800 votes. So thank you all for voting. Thank you for hanging out with me for all of this time. Tomorrow morning, we are going to go straight to closing arguments. 9 a.m. sharp. Be there. Be there, my friends, or be square. And then jury instructions, and then the jury will probably get the case before lunch. She's limited their closing arguments to 1 hour each, which I don't like either. I don't like it. I think they need a lot more than 1 hour to close on a case as crazy and as complicated as this one. I truly do believe that. Tracy, thank you so much for the Venmo. It's greatly appreciated. Paul says, Paul's a former federal computer investigator. He says, great trial coverage and insight. Thank you. Thank you, Paul. Coming from you, that means a lot. A lot. Oh, look at this. Melissa has sent me oh, Melissa, you are so on this. Thank you so much. Let's look at the jury instruction on Bowdoin. This is what she's not going to let the jury see. Do you want to see it? You guys want to see it? Melissa sent it to us, so let's see it. She's not going to let them see it, but we can look at it. It's entitled Omissions in Police Investigations, and so this is something that she is not going to read to the jury. And this is the instruction. Come on, guy, get out of the way here. Get out of the way. You've heard some evidence suggesting that the Commonwealth did not conduct a certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. Wait, why are they not hearing this again? I think this is like the most important thing that they should be hearing in this case, in my opinion. Here's the 3 questions. First, whether the omitted tests or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the tests or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you, and you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. Yeah, it may be in her discretion as to whether or not this defense may be used, but I think if there ever was a case in which to use this instruction, this might be it, in my opinion. That could be reversible error, in my opinion. That's nuts, in my opinion. What say you? Is there any do we have any Massachusetts attorneys in the chat? How often is the Bowdoin defense used, and when, if ever, do they actually read those jury instructions? That's whack. Tomorrow we'll start at 8:45. Court should start as usual at 9 a.m. It's crazy. Thank you, Brianne, for your for your Venmo. It says Sirens by Pearl Jam. We should add that to the list. And somebody bought me 10 matcha lattes. Thank you so much, Anon. Anon, please. And Brianne also for buying matcha lattes. In both ways, she contributed. Sirens by Pearl Jam. Melanie, you're just so classy. Thank you, thank you, thank you. It is a struggle daily, especially here. And Roxanne, thank you so much for the Cash App. It says I'm the most excellent with YouTube coverage. And Robin, thank you so much for the Venmo. You guys are very, very appreciated. So I will see you here tomorrow. Oh, and Lori, thank you so much, Lori. Said buy myself a treat on Cash App. Thank you, Lori. I will buy myself a treat with your very generous donation. And Justin for the final countdown. And Laura bought a matcha. Thanks. It says have a beautiful day. Thank you. Thank you so very much. You guys are awesome. There goes my hero, Foo Fighters. It's in there. We have it in there. It's in there. Marvin Gaye, what's going on? I think we have that in there too. There's no evidence. Yep. They kind of just make up whatever they want. Thank you, Mary. We're starting at 9. We will start at 8:45. The court will start at 9. Addie, thanks for becoming a member. And Chloe Albert's Revenge, thanks to the 5. Every time Lally's groupie speaks, I want to throw something. She's a catty, petty attorney. I'm glad she didn't do much else. This was bad enough. Is she giving the closing? Is that real? Is that real life? She has had no bonding experience with the jury at all, and she's going to get up and give the closing argument? Is that true? Ms. McLaughlin? Is it true? Thank you. Thanks, Elle. Celery says no Bowdoin equals Her Majesty's final punch. She won't allow it. She won't allow it, right? I'll allow it. I'll allow it like it's a putt in a match game, a golf match. What if any ending will be to this trial and this verdict? We will see tomorrow. Thank you to my moderators for keeping it classy today and for your tireless hard work and dedication to my channel. I love you so much. To my members, thank you so much. To the viewers, replay viewers, thank you so much. Please hit the likes up, the thumbs up thing on your way out. Helps the algorithm. And this morning was a Sean that was 4.5 hours of nothing because YouTube is striking it, which I really don't care about the monetization of the ad revenue, but what happens is it gets shadow banned and then nobody will see it. So that's what YouTube does. That's their little trick. They don't like it. Does that mean Lally will talk for a straight hour? Oh no. Yeah, Mary, unless McLaughlin is going to do that. And people said that the defense is going first. I don't know. Did we hear it? So yeah, no Bowdoin instruction, but they can argue a shoddy investigation in their closing, which I think is going to be good enough. But yeah, I think the defense goes first because it's the prosecution's case, so they usually get last licks. That would make sense to me. It's Massachusetts. It's like the wild, wild Northeast. the wild New England Commonwealth. So I think that may be true. That the defense would go first, the Commonwealth would go second. And that be that. So thank you. Oh, Liz Reed, are you Karen's sister? Says thank you for all your dedication in covering my sister's case. Thank you, Liz, for watching. Thank you. We're all praying for her. We're all praying for her. Bev said the defense goes first. And your family, Liz. You have an amazing family. Really do. Your parents are awesome. Your cousin is awesome. You have a really, really special family. And your sister, we're all praying for her. We've all been praying for her and sending strength, sending all the strength vibes to her because Karen Read could be any one of us. Right? I have questions. Whoever has the burden always has the option to go last. Look at that. It's like they flip a coin. It's like, do you want to receive or do you want the ball or you want to receive the, it's like a football thing, right? Like they flip the coin and they get an option. I can't even think right now. My brain is so spun. So they have the option. And they're going last. Imagine that. Lally wanting to get the last word. Defense goes first. All right, we'll see you tomorrow, guys. 8:45, I'll set it up. Make sure you hit the notification bell so you will be notified of everything. And I'm right here with you. You guys wouldn't miss it. I wouldn't miss it. Remember, as I always say, my friends, be cool, be kind, be classy. It's not hard, I swear. It is so not hard. Everybody try and get some sleep tonight.